Thank you so much for being here today. I'm Ray Dickey. I'm here for South Carolina, Hudson Valley, CAI, and also Association Health. Now we are covering many states, and I appreciate you being here. Today we are going to do collecting outstanding dues. This is like the third time we've done this program. I think it's a fantastic program. I think we cover just about everything. Before I go any further, we do the CEUs a little different now. Everyone has a question feature. You want to find that question feature and just type in CEUs, because there's a good chance that there's going to be a recorded version of this available for CEUs. And maybe you're watching the recorded version. Today is March 18th. And you're also going to need, during the recorded version, to use your question feature and enter need CEUs. You're going to have to do that a couple more times, because that's what I need to do for CMICB. I'm not king of the HOA world. I have to do what everybody wants. So I'm not Greg Girelli. I'm not in charge of everything. That being said, let's have our panel introduce themselves with who I see first, and that's Greg.
Good morning, everyone. Greg Girelli with Girelli Insurance Agency. We're located in Cold Spring, New York, and we do insurance master policy programs for condos, co-ops, and townhomes throughout the Hudson Valley and surrounding tri-state area.
Oh, thank you, audience. Yes, I love when people ask questions. Please ask questions, send comments. I don't use anyone's name, so feel free to ask away. Of course, don't send me anything too top secret, because you never know, I can make a mistake. Thanks for sending that, because I forgot to say that part. John.
John Legumina from the Legumina Law Firm. We're in Purchase, New York, just outside of New York City. We represent condominiums, co-ops, HOAs from New York City throughout the Hudson Valley areas.
All right, Corey.
Good morning, everyone. My name is Corey Kravitz. I'm an attorney with KSN. We're located in Boca Raton, Florida. We also have offices in Chicago, other parts of Illinois, and Indiana. Full service community association law firm. And thank you for letting me be here.
You're so relaxed, Corey, and you're like your whole office vibe is like so relaxed out of everybody on here. I just feel like you're going to go out for a walk in the beautiful Florida weather soon. You know,
it's raining today, but I worked outside for most of the day yesterday.
I mean, like John and Elliot and Dave, they look like they're possibly in prison. I don't even know where they are. Okay, Elliot.
Hey, my name is Elliot Engstrom. I'm an attorney at Sellers, Heirs, Dorch, and Liens. We're located in Charlotte, but I actually do have a beautiful window here of the Charlotte skyline. But if I turn my camera, you'll just see nothing. And we represent planned communities and condominiums located throughout North and South Carolina.
All right, Dave.
Good morning, everybody. My name is Dave Byrne. I'm the chairperson of my law firm's community associations practice, and Selgrim and Aaron, and we represent condominiums, HOAs, and co-ops in New Jersey, New York, and Pennsylvania.
All right, Adam.
Good morning, everyone. I'm Adam Clarkson, the founding shareholder of Clarkson, McAlonis, and O'Connor. I'm a fellow of the College Community Association Lawyers of CAI, and we service all of South Carolina from our offices in Charleston, South Carolina. We provide deferred fee collection, construction defect, contingency fee, and general counsel services.
Oh, somebody telling me that Corey's in Boca. Dawn.
Hi, everyone. My name is Dawn Becker-Drummond, and I'm a community insurance risk management specialist, or CIRMS. Acrisure is a national retail independent insurance brokerage, and we provide services for community associations as well as other types of businesses. But I'm the practice leader of the East Division, and I also serve on the South Carolina Board of Directors.
All right, so there's a lot to go over today, panel. So what I'll do is I'll do what we usually do and go through everybody. If you don't have to repeat what the previous person said, but by all means, if I go to the next question and you wanted to add something to the previous, please do. But I want to try to cover as much as we can. And I have a funny feeling there's going to be some differences today. So the first one I have is I have some questions. Oh, I got quite a few, but let me go through them. Do liens need to be re-recorded periodically? John.
So the answer in New York is yes and no. So I advise updating them is what I refer to it as periodically. But when I say periodically, like annually. But there's pretty good case law out there that says a lien is a continuing lien, and it does not need, you don't need to literally flood the county clerk's office with, there would be like probably like millions of liens if that was the case. So it's kind of absurd if you think of it like every single month you're just going to be doing just like hundreds of thousands of liens, and the county clerk's office would just be crushed with it. So you don't need to do it every single month.
Okay, Corey, same question, but also do liens expire?
In Florida, they do. For condos, you need to foreclose on that lien within 1 year, otherwise it will expire. HOAs, you have a longer period, 5 years. But it should never come, if you're on top of your books and your collections, you should never worry about your liens expiring because you should be on top of them and foreclosing.
Elliot.
North Carolina, there's a statute on point that says liens expire after 3 years. We take the position that means you have to initiate foreclosure action within that 3 years. In South Carolina, there's not a statute on point, but I always be careful to say, just because I'm saying your lien doesn't expire, that doesn't mean your lien couldn't somehow be extinguished, right? So you still want to be aware of what's going on the property, but there's not a specific expiration statute in South Carolina.
Okay, do me a favor, Elliot, you do North Carolina today, and I'm going to have Adam do South Carolina. Thank you. Appreciate it. Dave.
This is a good example of how it really matters what state you're working with when it comes to liens and collections and these things. It really varies. Like in Pennsylvania, you don't have to record a lien at all. The statute was amended years ago to make it that it's automatically a lien, which has taken a lot of collection lawyer work out of people that focus on Pennsylvania law. In New Jersey, liens do expire after a long time, and there's no obligation to foreclose them anytime soon.
So Adam, do liens need to be re-recorded periodically?
No. In South Carolina, they're good. As long as you record them under seal, they're good for 20 years. And if you don't, then they're arguably good for 5 years. But if they expire, they expire. So it's not, you don't magically resurrect them by re-recording them. But collection companies love to say that so that they can charge you again.
So Dawn, I heard in Florida, I think Corey said they expire in like a year. And if I heard Adam right, I think he said 20 years. It's amazing how things vary. What, Adam?
I was gonna say, it's just incredible. It's an anomaly, and as you know, I service in other states as well, and it's just, I think it's something that everybody would like to see in their state, but also it's one of those things. It's a case law issue, so we don't. It's better to do like Corey said. You want to keep them moving because you don't want to test that theory, because you could be the association that ends up not able to collect their lien. So you don't want to have anything that's sitting there that will.
It's so interesting, Dawn, isn't it? Like how much stuff varies from state to state. It's unbelievable. Okay, I'm going to hit the questions first, audience, because they may cover some of the slides I have. What kind of notice does an attorney need to provide a property owner during a foreclosure action? I'll go the other way around. Adam.
Again, it's the Wild Wild West here in South Carolina. So you're going to need to provide whatever notices that you have placed in your governing documents. So your, of course, your CC&Rs, your bylaws, they're going to dictate some of the preliminary notices. So a lot of them are going to be very similar to what some of the other folks are going to have in their statutes, which is going to be either a regular or certified mail to the homeowner notifying them of the lien and or the demand. They won't always have clarification like that. Sometimes it's going to be in the collection policy. And then, of course, as you move forward, notably, you're going to have to serve them. You're going to have to serve them just a civil complaint because South Carolina uses judicial foreclosure, which means you've got to file with the court, and you're going to have to either personally serve them or serve them by publication if they can't be tracked down.
Dave, how about your states?
Well, I think Adam summed it up, and it applies to really everywhere I practice. It generalized. Your governing documents may set forth notices that you have to follow before you foreclose, and then in all the states where I practice, any complaint has to be personally served unless you get leave of court, which you can get pretty easily. We do have in New Jersey some interesting quirk when it comes to liens. A long time ago, what we call our appellate judge, which is like one level below the Supreme Court, ruled that despite this being required by the actual statute, every recorded lien had to be served on the owner within a reasonable time after it's recorded. But the service is not like sheriff service. It's like in the mail. So you could have a problem if you can't, you have a problem foreclosing on a lien that you can't show you sent to the debtor within a reasonable time after it was recorded.
Elliot, any differences?
There's a few notices in North Carolina in the statutes you have to give, and without belaboring all those, I'd say the big one in North Carolina is that before you file your claim of lien, you need to make sure you've sent the 15-day letter required by statute, because that letter permits you to recover your attorney's fees and costs out of the foreclosure.
Interesting.
And if you don't send that letter, you might not be getting as much money as you think.
Corey.
Yeah, Florida's a little bit different. Florida statutorily has 3 prerequisite notices that need to be sent before we can file foreclosure. There's the notice of late assessment letter, which is similar to what Elliot was talking about, where if that letter is not sent, it's actually a 30-day notice. If it's not sent, then we cannot get our attorney's fees going forward. Then there's the intent to lien letter, the intent to foreclose letter. Those are both 45-day notices in Florida. Once the foreclosure is served, then all notices are done by email through the court system.
We started with such complex questions in the beginning and answers, and they vary so much. John.
Yeah, so it's pretty much in New York, it's like what Adam mentioned. It's follow your governing documents, look at the notice clause. And then if you are going to bring a lawsuit to foreclose on the lien or for a money judgment, you're going to have to serve them with process. So there's specific ways to do that. Usually you use a process server. New York doesn't have the 15-day statute that I heard, but you do look at your governing documents for how notices need to be served.
Okay. And I got a lot of my information from CAI. They have a lot of great publications, best practices on collections. I think they have a lot of forms and policies. They just have about anything that you could need if you're a member of CAI. You can go on national site. All right, let's hit some of these main topic points I guess these would be excuses. Could a board accept this as an excuse? And then I'm also going to ask the panel, should they? So I come to John, I come to you, you're there with the board, and I have a medical issue and I can't pay my bills. I can't pay the association. Is that a valid reason for a board to give somebody a break?
Well, so in New York, there's pretty consistent case law that the obligation to pay common charges, first of all, it's independent from any claims you may have. But more importantly, it's considered absolute. So there's really no reason I can think of that even a medical condition would absolve you from your responsibility. And I don't think you would need to give a reasonable accommodation by simply not paying your common charges. So short answer is no.
All right, well, let me do this then. So this is about ethical reasons that someone may have a legit reason that they can't pay and whether or not the board can accept it. The ones are medical issues, financial misfortune, plain compassion, and confidentiality, meaning like, do you have to disclose? But maybe we'll save confidentiality for last. So I'm looking at medical issues, financial misfortune, and compassion. So I'm going to go to the panel, add whatever you want to add. Elliot, what are some reasons that can the board, in your view, give somebody an out based on these reasons?
I would not recommend doing that. I always recommend to boards, you want to get your lien on file, because if people aren't paying their assessments, they're probably not paying other people too. And if you give them an out and there's a bankruptcy or something else happens and you don't have that lien, you're not protected. Whether to file the lien and whether to foreclose are 2 different questions. But I would not recommend holding off on the lien because of something like that.
Dave, is there any reason that a board could forgive or give someone a break if they are behind in their dues based on a medical reason, financial misfortune, or just plain compassion?
I don't think I don't even think it's negotiable. I mean, to me, it's a no-brainer. Everybody's got to pay. This doesn't matter why or what their situation is. I don't even think it's really debatable. I think the discretion comes in how you handle the balance once it's created. Whether you give people time to pay, whether you waive late fees, whether you, though I believe, in my view, boards have wide latitude in how the assessments are to be paid, but the idea that a person would not have to pay, that's not even on the table for discussion, frankly.
Okay. So Adam, I go to the board. I horribly lost both my legs in an accident, and I just don't have the money to pay the board. Does the board have the ability to say, you know what, we're going to give you a break because of that?
David, just to answer that question. So I agree with David, Elliot, and John. They've already covered all the details with this. I mean, there's really nothing. It doesn't. In all scenarios, it's going to be the same situation. I mean, there's if folks run out of hardships, if folks run into a situation where they can't arrange it, it's not going to cure itself. And generally, as a practical matter, homeowners should ideally put this ahead of things, because this is the equivalent of paying for water and power and insurance. I mean, this is something that should be an early pay, but folks like to kick it down the road. They like to think of it as something they can get away with not paying, because they'll show up, they'll ask for a reduction. They'll show up in their Mercedes and with their brand new iPhone and ask for a reduction while they're paying for all their other comforts and things, and they're not paying this, and basically shifting that obligation onto the rest of their neighbors, because when the association doesn't collect it, it does shift to the rest of the community. So there's really just not a concept, and as Dave was just pointing out, there's really not discretion to waive it, and so it's really just a movement. It's a matter of when. So certainly through the extra, they could delay, and they could get you on a payment plan. They could coordinate a method for you to figure out how you're going to handle that, but they wouldn't be in a position to waive anything.
So Corey, I would imagine this is a hard one for boards, right? Because someone's lived there for 20 years, everybody's friends, maybe they have a legitimate reason, something happened, somebody passed away. But everyone else, from what I've heard, has said, no, you can't afford to be compassionate as a board in regard to this issue. I guess what I'm hearing, Corey, is you have to move on with the process, no matter what their personal circumstances are. Corey, is that true or false?
No, it's true. And Dave and Adam nailed it on the head in their analysis. And I would just reiterate, the compassion can come in terms of waiving a late fee, waiving interest, doing a payment plan over a month or two, for things to work out. But the obligation of the assessment itself, like Adam and Dave said, is non-negotiable.
Dawn, where are we with insurance? Are we anywhere with insurance right now?
It depends. It's going to really depend if the owner who has the lien that's being enforced against them or pre-foreclosure asserts a counterclaim or a cross-claim against the association. And that's what we see a lot, because they don't want to pay. And so there's that, well, you didn't fix this, and you didn't do this, and you didn't do that, and that's why I didn't pay.
So Greg, I think what I'm hearing the panel saying, panel, jump in if I'm not, the board has a duty. The board has a duty. This is something that they have to do. If they don't do it, is this going to affect their insurance coverage, Greg?
Now the board, all the attorneys answered this very, very well. What we see is what Dawn alluded to is counterclaims and things outside it. You have a unit owner who has some hardship and they can't make their payments and they're looking for other ways. This is where you need to follow your attorneys, follow your rules, be consistent on how you're following anything, because we see a lot of discrimination claims. As Dawn said, failure of services and all these other items come out of it to distract from the I didn't pay my common charge part of things, and for them to hopefully win some money because they need money in order to pay these charges. So that's where we see the insurance claims come in. As far as delinquencies, insurance companies do look at the financial reports when we're writing and placing business and on renewal, and they do want to see a certain level of unit owners that are current with their payments versus in arrears, because again, you end up with an association with a lot of unit owners in arrears that could potentially lead to more claims in the insurance carrier's eyes.
So let's go hit some questions here. John, what if a board does not want to file liens and they believe that the judgments are more effective? Does the board, how much flexibility does the board have?
Well, I mean, boards have a lot of flexibility in deciding to pursue collections but as an attorney advising the board, um, first of all, liens are way cheaper, right? You just file them. Why would you go to, a judgment is you have to bring a lawsuit and win. And then a judgment is it could constitute a lien if you docket it correctly, but why? So you could easily do that, have done that with a lien. So I mean, there's different measures, but you really need to, for every situation, there's a variety of things you could do, and your attorney can give you advice of what your options are, and then it's up to the board to decide on what those options are.
Many people commenting in regard a couple times back whether or not people could pay. We're all on a fixed income. Everybody has a budget. There's a lot of comments in that regard that, look, everybody's got it tough, so everybody's got to basically pay up and do their share, which is, I think, exactly what the panel was saying. Dave, doesn't the business judgment rule require boards to take emotions out of the equation for collections?
Emotions. I don't know that the business judgment, it depends. I mean, I don't know. Business judgment rule would just require you not to operate in bad faith, or commit any fraud. I mean, emotion is, I don't know that it's necessarily a bad thing. I mean, I guess it depends on how you define it, but I assume emotion would be relevant to the type of consideration you would give to someone who needs help and time to pay. I don't know if it's necessarily a bad thing.
It's a hard question. It's a really good question. Doesn't the business judgment rule require boards to take emotions out of the equation for collections? Adam.
I mean, you're having me keep going after David, and David, he's covering it all. I mean,
Okay, good.
he's already covered it.
All right, let me hit you with this one. How to get around a unit owner that has had multiple bankruptcies with discharges costing the association over $30,000? Anything the board can do to protect the association? Adam.
Well, I mean, there's only so many. I mean, you can't just keep going. So it says multiple, but I mean, you can't keep going to the well. So there's really not that many that are in there. You've got to secure your interest, so you want to make sure that you get your lien in place. Elliot touched on that earlier with making sure that you get your lien in place before they do file the bankruptcy. That way you have a secured interest. Depending on what's happening, the lien could be crammed down and pushed off of the foreclosure, so you can, of course, be in a more junior position. But the key is, as Corey pointed out earlier, is to move the collection process along the line. I mean, because you want to be ahead of everyone. If you're not moving along the line, if you're passively addressing collections, you're going to get wiped out. You're going to be the folks that come in. You're going to put the bank try to come in, and they're already accumulated a bunch of debts, and you're going to be at the end of the line. So that's why you want to aggressively go after collections and keep it moving forward. And when I say aggressively, I mean just on a reasonable basis, in line with the governing documents, in line with a reasonable process of getting things through and moving forward. I mean, don't just sit on it. The folks that just sit on it are the ones that are going to lose their claims.
All right, so let's jump into this. Corey, I'll start with you. Bankruptcies, the Fair Debt Collections Practice Act, and get in line. I think they're kind of all related. I don't know if you agree or not, Corey. Can you cover those?
Totally, they're not really related. Obviously, bankruptcies are federal law. Fair Debt Collections Practices Act is also federal law, but that basically regulates how us as debt collectors can go about collecting the debt, and if we do it wrong, there's penalties for that. And I don't know what you mean by getting in line, but I guess priority of liens perhaps. But the whole key that you should get out of this, you don't have to worry about bankruptcy. You don't have to worry about these things as long as you're on top of your collections. There shouldn't be a situation, if you're doing things right, there shouldn't be a situation where someone's more than maybe 2 months or 1 or 2 quarters late in their assessments. It's a hell of a lot easier for us to collect 1 month or 2 months of assessments, or 1 quarter or 2 quarters of assessments, than it is 4 years. And it's one of those things where we'll come into a community that has on the verge of bankruptcy because they haven't been doing their collections. We clean them up, and then it's just staying on top of it, and you never get in that position again.
So Elliot, here's why I think that they were related. Okay. If someone's in bankruptcy and you contact them, you're afoul of the Fair Debt Collections Practice Act. You can answer that in a second. Tell me if I'm right or wrong. And then the thing with bankruptcies too, I wanted to talk about, Adam talked about it. You want to get in line, right? When someone files for bankruptcy. So if you could just kind of run with that, or just tell me that they're not even related, it doesn't matter. But if you could cover those 3 things, I'd appreciate it.
I think of contacting someone in bankruptcy and trying to collect from them. What my mind goes to is violating the stay that is put in place by the federal court at the beginning of the bankruptcy that says, in better words than this, leave these people alone because they're in bankruptcy. It's possible there's a provision of the FDCPA that says you can't try to contact somebody in bankruptcy. I'm not sure about that. But really what I think about is the stay, that as soon as they file bankruptcy, you can't try to go after them for debts until the bankruptcy matter is resolved.
Okay, so they're unrelated. Corey, thanks. John, Fair Debt Collections Practice Act. What is it, and should boards and managers be concerned about running afoul of it?
Yes, it's a federal statute. You have to give, I'll just try to really quickly summarize it. You have to give a notice. Really, like when you send a demand letter out, you put language at the bottom of it, giving the unit owner 30 days to request verification of the debt. There's a little bit more to it than that, but that's essentially what it is. And then it doesn't mean you can't proceed and collect. It just means you have to put this notice in. If you don't do it, it's just like what violating the bankruptcy stay we just mentioned. If you don't do it, it's strict liability, which means if the unit owner pursues it, you're going to have to pay some damages. There's no way, even if it's inadvertent, that's not an excuse.
Well, Greg, let's say I run afoul of it. I don't pay attention. I don't go to an attorney. I try to handle it on my own, and I have to pay. I'm liable. But I could just go to you, right? And have the insurance pay for my fines and get me out of this mess?
No, general insurance company's not going to pay for that type of a fine for violating an order like that.
So this would be a pretty serious issue for people to pay attention to, correct, Dave?
Well, I think I have to clear up a little bit of confusion. The FDCPA applies only to debt collectors. So the fine and penalty would attach to the lawyers in this particular instance, not to the actual association, at least in my mind. I mean, in my mind, the association's a first party debt collector. It's if you loan $5 to your brother and you write him a letter, ask him to pay you back, you're not a debt collector. You're trying to collect your own debt. But if you hire a lawyer to get the $5 back from your brother, that he's a debt collector. That law applies. There may be other debt collection laws that apply to the client directly, but the FDCPA applies to lawyers. So that's what we really have to be careful of. I find that we have to be careful of we have to be careful to not just automatically trust the accountings and numbers we see. We have an obligation, in my view, to dig in a little bit. Like, you can't just send a collection letter based on a total number you see. You really, in my view, have to look at the accounting to make sure it's not wacky charges and stuff. The other thing that's an interesting issue right now are whether management companies are considered debt collectors. There's a lot of case law across the country. It varies from circuit to circuit, which is a federal court term. And management companies have to be careful as to what they do, what they don't do. There's a lot of varieties. I don't have the time to talk about it now, but it's something management companies have to be careful about. Not direct employees that are doing letters, but I'm talking about management companies who begin to engage in what could be seen as collection activity.
I thought we were talking about that like 3 years ago, and they're still trying to figure that out all over the place. I know that came up quite a while ago about the management companies. All right, so I get this one all the time, Adam, or we get it all the time. Boards get angry, they get upset. I mean, they have somebody they don't deserve any compassion, right? They just don't want to pay their bills. They've lied to the association many, many times. They're a horrible neighbor. Just everything about them is just terrible. And the board wants to let everybody know. We want to let everybody know who this person is and what they owe. Why don't you summarize that for me? And I'm going to go to everybody because this could vary. Maybe it doesn't, Adam. Can boards do that?
I don't think this is going to vary, but no, boards cannot do that. Shaming people with respect to the collections isn't permitted because it's confidential information, the fact that they're delinquent as to the association. So in general, you're not going to be able to do anything about that or say anything about that. You're not going to divulge how far delinquent they are, that they sent you a nasty letter and why they're claiming they can't pay or anything like that, because again, it's all going to be confidential information. I mean, in general, rule of thumb, if it relates to an individual unit owner, it's information that other owners aren't going to have a right to review and see. So in general, you're not going to be able to do that. You can't post a list of folks that are delinquent, things like that. So in general, you wouldn't be able to do that. To an extent, there's a reasonable argument that you could, to the extent your board meetings, if your homeowners have a right to attend or the board is permitting them to attend, because in South Carolina there's not a right to attend, but some governing documents give it, and then a lot of the boards will allow it. If you have updates on active litigation, then arguably you could have a generalized disclosure explaining, hey, we have these five cases, in each case is a collection related case, and here's the name of the case. That's about as far as you probably could go. You couldn't get in much further without violating confidentiality and other information.
So Dawn, we've spoken about this one a lot over a lot of different live streams, but I'm going to go to the entire panel on this. Overwhelmingly, I've never done one of these and ever had an attorney ever say, try to shame someone. By far, they're like, don't try to be tricky with it. Don't ever do it. But I'm going to go to the panel because there are some tricky ways to do it, even though every attorney in the world is going to tell you not to. But this is something in this insurance rep you don't want to hear about, correct?
No. We really want everything to be happy and harmonious.
All right, so let me go through the attorneys really, really quick. Dave, is there any way you can, because some boards, man, they are so intent on wanting to shame someone.
I don't know, maybe I'll be in the minority here, but well, let me say it this way. I don't think there's any scenario whereby a board could shame someone. So I'll say that first. But my view that the delinquency lists and accounting records are absolutely not confidential. In fact, in Pennsylvania and New Jersey, owners have an absolute right to see them. So it would probably be a breach of fiduciary duty to refuse to show that information. God help the clients and the management companies. They have to make sure they're right, because wrong information will trigger some of the stuff Adam was concerned about. But owners have a right to absolutely see this information. When clients ask me whether or not the information can be published, I say yes, because owners have a right to the information, but it all comes down to purpose. I don't think, when I was in college and we didn't have enough money in the social treasury for a party in my fraternity, my buddy would put a list on the board and says, because these idiots, we can't have a party. And then by 5 o'clock they would pay. That, I think, would be a breach of fiduciary duty. But putting the information forward to owners, hey, by the way, you're paying an assessment of this amount because we pay the landscaper this much, because we pay insurance this much. Oh, and these people are having trouble paying. But posting the information itself, I don't believe to be a problem.
So Elliot, same question, and I'm batting zero with you guys today, by the way. I'm not even close. And I'm going to throw in potential selective enforcement on this also. I give up trying to guess if it ties in, Dawn. It's a rough group today. But Elliot, if you could run with the confidentiality, what you think about that, and also selective enforcement.
I mean, I generally wouldn't recommend, if you're pursuing collection actions against an owner, try to shame that owner or tell everybody in the condo that they're delinquent, that kind of thing. And in my experience, that usually doesn't come up in the board trying to shame the owner. It usually comes up in that owner blasting the Facebook page and the listserv talking about how the board are criminals, and the board wants to respond, right? And you got to be careful to the board to say, whoa, like, we're responsible for what we say, even if this person's not, right? So I do think the board has confidentiality obligations in North Carolina in the context of delinquencies. As to selective enforcement, I think where that would, selective enforcement is more of a claim that would be made against the board. I think where that would come up is we go after some people and we don't go after other people. And yeah, I mean, I could see that being a selective enforcement claim. Could also be a fair housing issue, right? If we're only collecting from people of one race or something like that. So they are. I will say this, Ray. On that, I do think that selective enforcement is a little bit related to collections, and that you want to be consistent and treat everybody the same way.
Corey, this is a very emotional issue for boards. I think Elliot hit it right, exactly right, because somebody's slamming the board on Facebook how horrible the association is, and then the board can't tell anybody that they haven't paid their dues for the last year and a half. Corey, commentary?
It's just unnecessary waste of energy, in my opinion. Hire the big guns, have us go after the delinquencies, and your job as a board member is to go to the meetings and vote on issues, not to get entangled in the drama of the community, which is a waste of time and why people don't want to serve on boards. So, the procedures are it's black or white. There's no, and in Florida, selective enforcement's not a claim, it's a defense. So, it'd be a defense to a claim the association is bringing against them. So, you follow your procedures, and the procedures are very efficient, especially in Florida. It's black or white. You either pay, you don't pay. If you don't pay, you lose your house to foreclosure. So any of the drama, and in Florida, there's no, the financials are not confidential either. So I would recommend against, putting a delinquency list on the clubhouse wall, and just follow the procedures that are in place, and it will fix itself.
Now, John, you have the opposite problem. You have multiple homes in multiple countries, and you're trying to you want to tone down how incredibly wealthy you are. But in regard to New York, yeah, I'm frustrated. This guy's out here slamming us and he owes a bunch of money. Can we tell anybody? We can't hear you.
I'm like Dave. I'm a little bit in a minority on this. So the issue is there an expectation of privacy, and the other consideration is, is there a reasonable expectation of privacy? And then the other issue is unit owners have the right to know how their common charges are being spent. If it's egregious, my advice for a client that really, really wants to publish it is you do not put a specific amount in, make sure they didn't file bankruptcy or on a payment plan, and then just make it like the following units are substantially behind in their common charges. Best practices, as we've all mentioned, is not to have to do it, but you did mention, Ray, that some boards just insist on it, and if it's not an absolute violation of any condominium law. It's just whether there's an invasion of their rights to privacy.
That brings me back to the potential selective enforcement. That makes me nervous, though, because if you do it for this person, theoretically, maybe you have to have a policy and do it for everyone. And I know you don't really have to, but it seems like you're setting yourself up here for a possible lawsuit, especially if they're a protected class or there's some kind of circumstances. Do you disagree, John?
Well, that's why when I met with the advice, I says the following units are significantly behind, and don't limit it just to one person you don't like. Anyone over whatever the threshold is should be included in that.
Okay. If you're here for
Ray, let me just chime in, Ray. I think that's why if you just publish, like John said, if a client is on you to do it, I mean, you got to be a lawyer and give them ways to do stuff they want to do without running into trouble. But publishing the actual financial data as it exists without any commentary or drama to it is, it's pretty plain that you're just publishing financial information, and that's what it is. And you keep it non-sexy, and hopefully that would minimize your exposure.
Non-sexy. I don't think that'll
Yeah,
be difficult.
right. Just to add also, if these people owe a lot of money, you're probably suing them. And the lawsuits is public information anyway.
Right. Good point.
Right. Then you go back to Adam's advice where you could theoretically bring up some kind of litigation or something. Adam, did I get that right or was I wrong? Okay. Adam loves when I quote him. He absolutely.
Right. Whether you quote him correctly or incorrectly.
He has full confidence in me. Dawn, I feel bad we don't have a lot of insurance stuff. Could you do my CU thing for me? Oh,
well,
wait a minute.
I have
All right,
insurance.
hold on a second. Hold on a second.
and
Wait. CEUs. If you need, I have to do this part. If you need CEUs, use your question feature right now and put in CEU. I need CEUs. Ray, you're great. I need CEUs. As long as it says you need CEUs in there, go ahead and put it in there right now. Okay. Dawn, go ahead.
So I talk a lot about DNO not covering bodily injury or property damage. Property damage can also be I'm not going to say this word probably, a devaluation, you know the word, lowering the value of your homes. I just can't get it out. The other aspect, yes, it's hard. And then the other aspect is invasion of privacy. We talked about that. That's going to be a DNO claim. Most insurance policies may or may not cover it. Check your policy. And then defamation. But let's talk about some of the other nuances. And Greg, I'm probably going to ask you to highlight this more, but foreclosure exclusions, specific matter exclusions, and then of course we get into individual exclusions where we name people or directors, and then of course the accounting and taxes, as Greg pointed out, are not covered.
All right, so Greg, Dawn is saying there's all these things that involve collections that you're not going to get covered for, that you may think that you're covered for and you're not. So can you mention a couple of the other ones?
Correct. I mean, if everybody's watching this, Dawn and I both perked up as this conversation rolled down, because this is a very fine line to be treading here, where you're in a retaliation standpoint, where you're trying to go tit for tat if you're trying to shame someone on this. And on many of the instances, like Dawn just mentioned a few, there could not be coverage when you're looking back to your insurance company, that we ended up down this rabbit hole. And we're in an area where the insurance company is not going to pick that up. So you really want to understand your D&O coverages. She highlighted a few very good ones.
Dawn does love insurance. There's no doubt about it. Okay, let me hit some of the questions here. There's a lot of them here. What about if they fail to pay current dues? Can we get it released to move forward? Dave.
Power just went out.
Well, at least we had a heads up.
Yeah, so I'm in the office, but we just had a power outage. I don't know, maybe I got a missile strike here or something, but nothing's happening.
All right. Did you hear the question? You want to answer it? You're still here.
Oh, you can move on to one of the other guys. They're smarter anyway.
Dave's he's all misconstrued now. He doesn't know what's going on. He wants to know what's going on. Okay. Adam, what about if they fail to pay current dues? Can we get it released to move forward? Can you explain what the question means? Because I don't understand.
I think what they meant to say, I think they're talking about the automatic bankruptcy stay and whether or not the stay can be lifted. Stay is lifted is what the term is. And yes, you can get a lifted stay to move forward with collections in the event that they're not paying the post-petition debt, being that they're not paying after they filed for bankruptcy and they don't pay the incoming new debt. That you can come back and get a lifted stay and move forward. Now, the reality is, financially, does it make sense? In most associations, it does not. If your assessments are less than probably $400 a month, it probably doesn't make sense to toy with that, because you're talking about spending a few $1,000s to get a lift of stay to move forward collections. So you're probably not gonna. It's probably not gonna have value to you. But if you're in a high rise and you've got $1,000 or more a month assessments, it probably will make sense. But again, you're going to be spending a few grand to get that lift of stay, assuming, and that's assuming you even get it. You may spend a few grand and not get the lift of stay. The bankruptcy court may deny it. But if they're not making the payments and whatnot, then there is an ability to do that. That's an option.
Corey, if you are, and by the way, panel, jump back if you want to. Corey, if you are budgeting significant bad debt expense in subsequent years for doubtful accounts, and the funds become collectible, Do the owners in good standing have any claim to the recovered funds?
I mean, they can ask for it, but generally the board has discretion of what to do with those funds. I typically, if I'm preparing a budget, I would not budget for bad debt or expected bad debt, because like I said before, the board shouldn't be letting the delinquent payments sit on the books. So I would avoid the whole situation, completely, just by going after the delinquencies in a timely manner.
Elliot, what are the requirements for an owner to remain current going forward after the bankruptcy has been filed? Do you have recourse if they continue to fail to pay after the bankruptcy?
I think that, so I don't practice bankruptcy law, so I have to be careful. I pass those off to other people. But my understanding is that that involves going to the bankruptcy court and saying they're not using this process right, or they're not paying what you've said they're supposed to pay, and goes back to the lifting of the stay. Without the stay being lifted or being included in the bankruptcy plan, I'd be nervous to try to go near that.
Okay, I have to go to the panel on this one, but the next question I love. I love this question. It comes up every time. I can't wait to ask it. But taking a step back very quickly, Adam, anything different to say about that than Elliot said?
You just asked Elliot the same question you asked me, but you put it a different. It was just used
Okay.
different words. But
All
the
right,
obligation is that after they file the debt, after they file for bankruptcy, they are supposed to be making payments of the upcoming debts, and then the process is exactly what I explained earlier. So it's just But so we're and Elliot and I said the same thing basically.
Okay. I thought Elliot was a lot more glamorous when he said it, a lot more sophisticated, but that's okay.
He was more glamorous, but
He's a lot nicer about it, maybe. Okay.
Well, I mean, nicer to you, maybe.
Elliot is very nice to me. Thank you, Elliot. Thank you very much.
Oh, yeah.
Okay. Here, anybody want to add any commentary to that? Okay.
I'll just add one thing, which is that when someone files a bankruptcy, especially at Chapter 13, I think management companies often make a mistake of not segregating and separating the accounts. We find that to be a big problem. So if a person files Chapter 13, the management company and the association should still be sending regular statements to get paid post-petition, like Adam, I think, just mentioned. But that statement can't have on it the amount of money that was covered by the bankruptcy. Otherwise, it's technically a violation. And John mentioned earlier, like sanctions for that. So that's a really important thing.
Okay, here's the question that I love. It comes up all the time. I always get different answers. I'm so happy that somebody asked it. Can a board remove parking privileges for unit owners that are behind on their association dues?
Well, yes, the answer is yes. Both in Pennsylvania and New Jersey, the statutes specifically authorize that. In Pennsulvania, it's very easy to do, meaning if the person's delinquent and the parking is common element, it's pretty much it goes without challenge. In New Jersey, you have to provide some additional notices, make ADR available, and that sort of thing. But generally speaking, if parking is common element and absent some crazy provision in your governing documents, in New Jersey and Pennsylvania, it's definitely a doable thing.
Elliot, let me re-ask the question because I may want to use it as shorts. That's why I like to re-ask the question. Elliot, can a board remove parking privileges to unit owners that are behind in their dues?
In North Carolina, yes. What you're referring to is suspension of privileges. You have to use what's called a notice and hearing process that is laid out by statute. Of course, the statutes of North Carolina say, unless the governing documents say something else, so you need to know what your governing documents say. But the general answer is yes, as long as you follow the proper process.
John, can an association take away someone's parking if they are behind in their dues?
In New York, it's only if it's in your governing documents. So in most cases, if it's condominium, so the answer would be no, because they don't have a suspension of privileges provision. Most HOAs do have a suspension of privileges provision, but you have to look at it because sometimes they'll limit it to just like voting. So in many times it's just silent. So you just have to definitely look at it.
Adam, in South Carolina, can an association take away your parking if you owe the association money and it's late?
It's going to, similar to what John said, it's going to depend on your governing documents. And, and most governing documents aren't going to provide for that. Most of them aren't going to allow that. That's usually not something that's contemplated by the document. So most associations won't have the power to do that. It's pretty rare to see something like that in there because usually it's not even contemplated by the original declarant. And then the other thing is, a better question is not can you, but should you? Should you? No, you shouldn't. Not unless you think you look really great on the 5 o'clock news and you like to be a villain in the eyes of everyone that can see the radius of whatever it is, Fox 5 or Channel 2 or whatever you're going to be, whatever range you're going to be in, because eventually it's going to go south. It's going to be a bad look, and you're going to be the person that gets our new statute on why we can't on restricting other things in community associations because of that situation. So it's not a great idea, even if you could theoretically do it.
Corey, I saved Florida for last because I feel like in some ways you could do whatever you want in Florida. You can blow people's cars up. You could turn them upside down. I mean, what can you do in Florida if someone is behind in their dues and you take their parking away?
I think parking's probably not something that would be taken away just because the way it's set up generally, but more commonly, what they'll do is they'll disconnect your barcode or clicker for the security gates and force you to go through the guest access. And that's usually a pain in the butt because the line for guest access is usually a lot longer than just cruising through the resident lane. And that actually gets people to pay pretty efficiently. Additionally, that the association can suspend the common area use rights, which means can't go to the pool, can't go to the clubhouse, if you don't pay. So that's some of the enforcement mechanisms in Florida. Parking's not really an issue because people will, in HOAs, they'll park in their driveways. That's theirs. And in condos, sometimes the parking spaces are deeded, so you wouldn't be able to suspend that.
Okay, let's move quickly because we want to do closing thoughts. Small claims court. John, should associations just do it on their own? They're always looking to save a buck.
They can try. Should they? It depends how well they do it. But no, I don't have a problem with my clients trying it.
Corey, should they?
In Florida, I don't believe they're allowed to. I think corporations in Florida are required to be represented by an attorney, so they wouldn't be able to.
Elliot, should they?
Sending an attorney, but can an entity try it on their own? I guess they could try, but I would recommend having an attorney do that. And also, I think one thing you have to look at is depending on the amount of money, do you refer it to D&O or not? That's a separate question.
Dave, should they?
Well, in Pennsylvania, it's not really an option. There's different types of court systems and the like, and you have to combine your foreclosure with your money judgment action, and that requires a lawyer, so it's more complicated. But when it comes to New Jersey, I agree with John. I think that I've often told clients this. There's no obligation to use a lawyer if you want to bring a claim against an owner for, I think it's less than $3,500 now, or $5,000 maybe 3,500. No obligation to use a lawyer. You could try it on your own, and but you can't foreclose in New Jersey without a lawyer. You can just get a money judgment without a lawyer in small claims, and there's no reason why you shouldn't try it. But most associations don't do it. They'd rather not be bothered because you'd have to do all the paperwork. You have to go to court. Oh, that's the one last thing. In New Jersey, when you do a small claims action, it's all done in one day. So you have to show up. It's not like a lawsuit where you can hope the guy doesn't show up for you and then you win. In New Jersey, you have to sue and you have to show up. If you don't show up, then you lose.
Adam, what happens if you take someone to small claims court and you lose? Can an attorney go back after him?
Well, I think you do that. You're looking. I was going to say you open this up because Elliot pointed out the D&O issue, which I was going to kick over. I was going to say Don Greg are probably chomping at the bit because if you're a board member or a manager and you go to small claims court, you lose, probably not going to be covered by your D&O because you just committed gross negligence, willful malfeasance. In South Carolina, you're not allowed to go. So you've got to be represented by an attorney. But I mean, you can appeal. An attorney could appeal just like they could appeal anything else. But if a homeowner or board, I mean, if you had a board member or a manager did it, I can't imagine they're going to have done everything they needed to do to set up the situation for an appropriate appeal. But also going back to the question that John pointed earlier about the judgment, I mean, it's silly to do it because you go, let's say you get a judgment in small claims court. Okay, great. What are you going to do with the judgment? Well, hopefully you're going to try to secure it against the home as a lien. So why would you do that? Why wouldn't you just go and get a lien? It doesn't make any sense to go to small claims court unless you don't know what you're doing.
If you are here for CEUs, you got to send it to me one more time, please. Send it to me one more time. Just put in the question feature. I need CEUs. I need CEUs. Dawn, I'm so sorry because I know how busy you are. Greg's not that busy usually. I think he lays back and has a lot of people serving
He
him all
gives
day.
all the work to Deb.
But anything you want to tell us, Dawn, any more insurance stuff or just anything in general you want to share? Because I feel bad we didn't have a lot of insurance stuff today.
No, but there's also maybe acting outside of your scope of authority. Do not practice law without a license. Do not conduct financial audits without the assistance of a CPA. And also, when it comes to collections, if you need legal advice, you should get it. I think Greg and I get a lot of phone calls from people who talk to us first and then want to know if they should go to the attorney.
And audience, panel, we got like 3 minutes here. Greg, really quick, I have a question for you to use up your time if you don't mind. I'm driving up for our event tomorrow in Hudson Valley. We have a reverse expo. It's going to be packed. I'm waiting for my invite. I have not got my invite from you and Deb yet to stay over at your place tonight. Should I just head right over there to your home or should I maybe go to the hotel first?
I'll meet you at the restaurant.
All right. Closing thoughts, Greg. That didn't sound like an invite, but go ahead.
I had one more item I wanted to point out for people to learn. This surprises boards and property managers sometimes. You have the person who's been continuously in arrears and behind and doesn't pay their common charges. The property insurance policy includes loss of income, which is an indirect damage. And then that building, let's say, is in a 5-unit building, gets destroyed in a fire. The policy pays for uncollectible common charges. And if it's shown in the documents that you haven't been able to collect for that unit owner previously to the fire, you're not necessarily going to be able to collect from the insurance company during the time, let's say 18 months it takes to rebuild that building. They're going to deem that to have been uncollectible anyway. So you may not get insurance monies for those common charges for that time period that maybe you would have thought or expected to. And I had boards be surprised on that one, but it needed to be collectible.
Is it ever good news, Greg?
No,
Okay.
no, it's usually doom and gloom with all your questions, Ray.
I know. Very quickly. We only have 2 minutes. John, very quick. Closing thoughts.
Yeah, so I actually saw the same situation that Greg just mentioned. So as Corey's been mentioning, stay, best practice, stay on top of your collections, let your attorneys do it, and you'll see good results. It might not be immediate, but you really need to just refer to your attorneys and let them do what they do best.
Corey, Adam's going to go last, so very quick because he hates having any time taken away from him. Sure. Corey, closing thoughts.
Don't use attorney's fees as an excuse not to go after your collections. We're really good at what we do. Many law firms, including us, we will defer our fees and actually advance the costs. So the collection action may cost the association absolutely nothing. Stay on top of it. It's probably your most important duty as a board member.
Elliot.
Get your liens on file. If someone is delinquent, get your liens on file. You do not have to decide that you're definitely going to foreclose on somebody just because you get your lien on file, and that lien protects the association.
Dave.
I would say that I think it's important that boards, while equal treatment is important across the board, I think boards should also try to look at each individual delinquency as a separate and distinct sort of legal problem. Some owners require more aggressive tactics. Some require maybe less aggressive tactics. Some owners have earned the right for payment plans. Some have, some have abused their rights to those things. So I think that each individual delinquency is an individual legal problem that should be treated as an individual legal problem.
Adam, take us out of the program.
I would say don't be afraid of the foreclosure process. A lot of boards, they get freaked out, and managers in their first time coming in, like, oh my gosh, we don't want to foreclose, we don't want the property. They're worried about all these things as if it's the first time that the attorney's ever handled it. It's not. We've done thousands of these. Everybody on here, in between all of us here, we've probably done tens of thousands or hundreds of thousands with attorneys you just have in the film you see today. But only, maybe 1 to 3 and 200 starts ends up as an actual foreclosure. It's very rare that they actually end up foreclosing, and the goal is not to foreclose. The goal is to collect the money. And in most situations, homeowners will come up and they will eventually pay. So, don't be afraid of the process. It's not as scary as it seems, and just let your coordinate with your professionals, let the professionals do your work and guide you through it.
I want to thank everybody for being here. Dawn and Greg, thanks for hanging out today. I know it was I appreciate your time's valuable. Thanks, everybody, and I hope to see people tomorrow, Hudson Valley CI Reverse Expo. Bye, everybody. Thank you so much.
Thanks.